Hello, it's John Thynne here with Peter Haley. We're both directors in our forensics division at Vincents. What we're looking to talk to you today about is there an alternative to financial disputes? So I thought we'd actually start by having a little bit of a look at what the combative litigation process looks like. Peter.
Okay, so that sort of highlights a little bit the costs of litigation, where you've got financial cost, lawyers, barristers, experts, us and other advisors.
That's our typical sort of, when we look at the cost of litigation, we always go, what's the actual financial cost? But what we don't normally take into account is all the other costs that actually come into being. And they're quite often more detrimental than the actual financial outlay that's there.
And they're those following dot points there, the time invested into the litigation process. So often, this can take up 1, 2, 3, 5 years of people's lives. It just drags on. And if it's a financial dispute involving their business, or it might be their matrimonial dispute, for example, while they're looking after all that, they take their eye off the ball in their business, and there's a cost to that as well. I mean, we often do valuations of businesses where you can see the performance dropping off. Separation might have been 2 years ago, and in the meantime they've been negotiating a property settlement, and the business owner just hasn't got their mind on the job at all. And then finally, that might get to such an extent that the business owner has a loss of mojo, and he's just decided it's all too hard. Why would I bother going on with this? So then the typical sort of way that a forensic accountant is involved in that typical litigation process is for valuations, economic loss reports, financial determinations, and so on. And the scope is set by the lawyers in terms of what the forensic accountant is to do, and that's set out in the instructions. There might also be some limitations and assumptions, although they might be created by the accountant himself or the other expert involved. When they get into the job, they realise that they don't have all the information required, or they have to make certain assumptions. You then lead to reviewing and analysing and investigating the financial information, preparation of a report, which then is obviously sort of a flag in the sand, and it sets a certain level of that each party is suddenly fighting around. And then following the issuing of the report, there may be questions raised. So the typical issues with that sort of process is it's written by an accountant, or this might be other expert, and the parties and their legal advisors aren't. That's the reason why they need an expert. They don't know about that sort of thing, and there's just a total or partial lack of understanding of the content. As I said, it encourages the parties to become positional, because, for example, with a forensic accountant's report, it might be a valuation and it says it's worth X. Each party's probably already got in their head what they think it is, and neither of them have got a number or anything like X. And one of them might think X is a good number, and one of them might think X is a bad number, and then they sort of fight over that. Often there's a perception that experts' reports can be long and difficult to follow, and there's a lack of agreement sometimes on the assumptions that are adopted. You could also get the issue where one party alleges the other party has provided misleading input, and that's obviously up to the expert to test any inputs they're given. And then the same way that if the non-business owning spouse, for example, in a matrimonial dispute, might have no input into it, and there's a perceived bias because the experts just trotted out what my ex has told them. And sort of in an extreme example, that can end up with an uncommercial result.
Or a perceived uncommercial result. That quite often we have the working party will say, you could never sell it for that much. And they're not actually investigating why, or don't understand the process that's gone into it.
And then, we often see with our reports all these backseat experts come out of the woodwork who think they're an expert on business valuations, and put forward their 2 bob's worth on all those factors rated there, capitalisation rates, tax, should it be taken into account or not. This then leads to a lack of transparency, time drags on, and there's issues then with subsequent questions, which of course all leads to more and more cost.
Just a quick example. These examples we've had through the office previously had a farming loss. The only issue was the quantum. The plaintiff's accountant was instructed, and they followed the pleadings and produced the first report. The plaintiff now gets anchored to that first report. The defendant's accountant critiques that first report, says what's wrong with it, and the defendant is now anchored at another point. The plaintiff's accountant does a further report, report 2. Defendant accountant critiques report 2. We then get further entrenched into their individual positions. The plaintiff accountant does further work and realise the pleadings they were initially following were incorrect, and they need to start that process again. At that point, 2.5 years down the track, 200 grand in combined accounting costs, 500,000 in combined legal costs. Was there a better way to do it?
And remember, this is an example on quantum only. So often, as accounting experts, we only get involved after, liability is the first issue often, and then quantum's almost a secondary thought. So sometimes this one was only to do with quantum, but you might have gone through that same whole exercise just nutting out whether there's actually a liability issue or not.
And you quite often get the solicitors and the accountants who are preparing the work and the advice in the situation haven't been given all of the details. They believe they're working with a full deck of cards, and not uncommon to actually find you're not.
And also, I mean, their clients have, potentially got a biased view about things, and they've sort of led the lawyer onto a certain path and assured them. And it's only when the accountant gets involved, 18 months, 2 years down the track, they start thinking about quantum in a bit of detail, they realise that maybe they're fighting over something that's not worth fighting over because the numbers just aren't big enough.
So the question today we're trying to consider is there an alternative in relation to the financial dispute? And the answer to that is quite often the case, is maybe, maybe not. Litigation lawyers have its place, and we're not talking about the legal dispute that's in place. We're just purely talking about the financial side of it. When considering it, it's a case-by-case basis. There's no one size that fits all. We're looking at, is there a way to actually customise that financial dispute process? And one of the important facets of that is actually educating the parties, which we find is quite often one of the issues. The actual parties become anchored to a point without actually understanding the process or the inputs that have actually gone into determining an answer. So one of the things we think is extremely important is to make sure you educate the parties so they understand how things happen and what the drivers behind that are.
For example, you might have a matrimonial dispute, where the wife wants the house that's got $500,000 worth of equity in it. To get that, the business has to be worth the same for the husband to take the business. So they're just entrenched in this position for no particular rhyme or reason, and thinking, oh, the business makes good money, it must be worth $500,000, it must be worth that $500,000, and they've just got that position. And by undertaking this process where you educate them as to why a business would or would not be worth $500,000 is often quite enlightening and quite useful.
The other things that are important in sort of designing this sort of process is to allow both parties to be heard. We quite often find some of the issues that one of the parties just hasn't actually been heard, hasn't had their voice listened to, the issues they're raising. And if you actually address those things, quite often the boundaries start falling down. And also in that dispute process, I'm not trying to understate how important this section is by having it last, but understanding what the parties' interests are. What are they trying to achieve, as opposed to looking at their positions? And this in itself is its whole another seminar or series of seminars, interest-based negotiation. But it's an area that when you delve into it, actually, again, it can help actually start breaking down those boundaries. So what are we looking at? From a financial viewpoint, we're still looking at the accountant or the person resolving the financial dispute. We're still looking at actually their role being a single expert or a joint appointment if it's not actually within the legal arena. The parties provide outlines together of the relevant financial data. So there's input from both parties telling their side of the story, or their version of the truth, what they understand it to be.
And that may not be different to how a typical engagement is undertaken either. So the first couple of things, and point 3, the data being reviewed and whatever, that's not necessarily any different to that typical process that we set out earlier.
And it's very much just trying to actually understand the background, understand the inputs, and actually set it up for that next stage. Once we actually get all the information collated, the next thing that happens is a conference is held. Everyone comes along to that conference that can actually assist in what's happening. So the parties are there, the solicitors are there, comfort people for the parties, but also their advisors. So if one of the parties has an accountant who's quite vocal, what we do is encourage them to bring them along. They'll actually provide their input, and we can use them as one of the actual resources in the room. The issues are canvassed, what we actually agree upon, what's the meeting about. The next stage, which is really important, is to actually set out the education side of it. Before you can actually ask people to advise or to consider making decisions or having input into something, they need to understand what we're talking about. So for instance, if we're talking about a valuation, what we're looking at here is to actually do a short valuation presentation. Talk to them about what is value, what is the definition of value, what is goodwill, what are the methodologies out there. Very simplistically, very briefly, but so they understand the process that we're following. The next thing is actually to learn the lay of the land. You need to actually start getting the parties comfortable to start talking. So the next thing we try to do is actually look at the trading performance. If we're looking at evaluation, we'll carry that theme through. If you're looking at evaluation, the next thing we'll do is actually talk about the trading performance. Tell me about the sales. Tell me how your customers. Tell me how the employees work. How's the business managed? How long has it been going for? Tell me about where it actually works from. So essentially, we do the site interview in the room, but what we find is it's very transparent. Everyone can hear the questions, everyone can hear the answers, and can participate in what's there and ask their own questions. So it gets a little bit of dialogue going on a fairly neutral ground. We'll then dive in and actually do the quantification. So again, if we're doing evaluation, we'll actually do the valuation on the board. Now, the important thing here is that point 1, we're doing this as a single expert. This is not a mediation. This is not a facilitation process. We're using this forum to derive our result, which is not dissimilar to what we do externally, but it's just perceived differently from the clients, and they can buy into that process. And that buy-in is extremely important. We come up with our conclusion. Then we have the reality testing and feedback time. So instead of in the normal process where we'll produce a report, it goes out, parties read it, questions come back, we have our time frame, we respond to those questions, all the messages lost going back and forth. This is all done live at the point. So the working spouse says, valuation's ridiculous. No one's going to sell it pay that much money for the goodwill. Why not? Let's go through that process. Let's get your accountant involved who's sitting in the room. What do you think? And allows for that real-time feedback and reality testing. And from that point, the aim is to actually agree on the actual financial result, and the parties can then go away and negotiate. Whether they do it there, they do that with their solicitors, they move away to mediation, whatever process works for the parties and the solicitors. Just as a quick example, if we're doing an education part of this and it was evaluation, this was the sort of things we'd actually go through. The first thing we'd do is go through what's the current economic climate. If you were to sell the business, what sort of things need to be taken into account? And we look at that sort of quick overview of the economy.
Because ultimately, I mean, it doesn't really matter what sort of business you're in. If it's some sort of financial dispute, what the future is going to hold is determined to some extent by the economy as a whole. So that's sort of the basic first thing we go through.
We then actually talk about value. What is value? People talk about value without defining it, and we just give a good overview. There's a lot of different values out there, and this may well be where the party is actually in conflict. If they're talking about that business that's worth more than that, what they're talking about is that last one there, value to party. That person has a absolute key person issue. He's got an integral relationship with a whole lot of real estate agencies, and those real estate agencies refer work into him. In that case there, that business is worth more to him than it might be to someone in the street. So what are we actually working out, market value or value to party? So defining that early on can, again, start resolving some differences. We go through and actually talk about what some of the definitions of market value are, so they understand what we're trying to achieve. We actually talk about what is goodwill. There's a big perception out there that goodwill is all about these facets of the business, when goodwill, what we can sell, is all about the actual profitability.
I mean, this is actually one of the questions I came back to me on one of my valuation reports last week, that the conclusion was the business had no goodwill, but the non-business owning spouse was querying, well, we've got all these repeat customers who keep coming back. How is that reflected in the goodwill? And the answer is, well, it isn't. If those repeat customers don't result in profits being generated, well, there's no value to them in that way.
So it's all about the profits. We need to explain that concept to them. Keep in mind, what we're trying to do is to educate the parties so they actually buy into the process and understand what the drivers are behind what our result is. Go through some of the methodologies and maybe go through some quick examples. So again, that's that education process we go through. What are big differences in this approach? One of the primary ones is that the parties understand the process and what the evaluation means, and they can target where the actual drivers are and focus where the actual ongoing dispute is, if there is one. So for instance, the evaluation, that the dispute may be in relation to, has a business got those clients or not? So we talk about the clients as opposed to talking about the valuation as a whole. They participate in the determination and take ownership of the outcome, which is extremely important. The process is transparent, so any level of bias or sort of the expert being misled by one party start disappearing. As the party's been involved in the determination, they're not anchored to a result. They're actually anchored to a process that came out based on the drivers that were input. So we actually changed from saying that result is too high or too low to, I've got an issue with what you believe the forecasted sales is going to be, or what your actual commercial worth is. And the big one there, it's real-time evaluation. This process is designed to be a lot faster. And if there's any dispute that can't be resolved in the room, then we actually have a focused resolution on how to actually resolve that dispute and reconvene.
And it might well be that, again, I've got another matter at the moment, that the initial aim is just to go through this process, hold the meeting with the parties and hopefully agree on a value. But if that's not done, then there's potential that we then prepare a standard type report, which can be filed in court. But I mean, the difference between this sort of process and just doing that report is obviously that you're not just relying on one form of communication, being the written word. You've got written word, which is basically worksheets and things that we put up on the screen as part of the education process. We've also got verbal and other visual ways of communicating in person, which allows that immediate question to be asked as soon as there's something, it's an issue. Oh, can you just stop there? Can you please explain to me why you're estimating sales will be X in the future? And there's just that, rather than when you get a valuation report or sort of any sort of accountant's report, people just tend to focus on that summary paragraph and watch the number and don't necessarily understand all the inputs. As we say on point 4 there, they've been involved in they have buy-in and have input into each of the things that ultimately make up that final number.
So we can use this process. This process can be used in a whole range of applications, and it's essentially where there's a financial dispute or a financial disagreement that comes in. It doesn't need to be litigation. It can be any form of dispute. Commercial litigation, people buying in, selling out of businesses, shareholder disputes, partner disputes, family law, estate law. If there's a financial dispute, this process can be used. And that's really where we're coming from. The traditional approach always is to, if there's a financial dispute, outsource it, get a report done, and a bunch of paper comes back with an answer in the executive summary. We find that process, it definitely has its place, but quite often it actually is the cause of further disagreement. Is there a better way to do it? There may well be. There may not be in the situation you're looking at, but there may well be where the parties can actually get buy-in to what they do and understand what the outcome is. Quick final example, and this is what we're finding this is actually being used for a lot, is people actually buying into professional practices. In this case here, senior associate lawyer wants to buy into legal practice. The legal practice, 3 partners offering various services. Firm is heavily relies on the employee and wants future growth. However, the views of current performance, the employee reviews current performance as their asset, where the employer views the current performance as what they're producing. The employee is keen on the future of the firm, but knows what his personal worth is and knows he could actually move to someone else, and there'll be certain clients that would follow him. Preliminary negotiations over a number, but limited agreement and general lack of knowledge of how to value a business from both sides, but they're arguing a result without understanding that. We came in, did the CDR process, this process we're talking about. What we found was the employee and the employer gain an insight into the operation of how to do a valuation. The employee understands how the firm operates, and was extremely important process for not only buying into the business, but also, and valuing the business, but also they're buying into the performance of this business long term. And what we often find is that there is, in this type of situation, there's too much focus on determining a number, a value for buy-in, and not enough focus on what's going to happen day one onwards, where they need to be on the same page to actually make this business work well.
And the person who has been the employee has never really been, all they got was last year's profit and loss account and balance sheet. They never really understood where the clients were coming from. They were just involved in their small part of the business and weren't really involved in the business as a whole. It just gave them a much greater insight. The other one, which we haven't got a slide for, but where this often is very useful too, is in partnership splits, where sort of they're splitting the whole, and maybe the sum of the parts is worth less than the whole, and they know roughly what it was worth when it was all one big happy ship, but now they're going to have two smaller ships sailing off. What are they each taking away, and what does one owe the other to sort of even things up? And it might be that they've actually both cost themselves a fair bit by splitting, because two small firms might not be worth very much at all, but together they had synergies and economies of scale and so on.
We often find that with accounting firms, and this is probably the example we're both thinking of, is the accounting firms, where you had one premise beforehand, now you have two premises. You have one receptionist, now you've got two receptionists. You just don't have the same, for a better term, buying power. And we've just jumped ahead. Look, thank you for today. That's really what we wanted to go through, and actually just put a little bit of thought out there. Is there a different way to do it in certain circumstances? So thank you.